Okay, the Bill of Rights is this unit's lecture. To begin, the U.S. Constitution created Congress and gave it lawmaking power. The Bill of Rights describes how substantive laws are carried out. The first 10 are basically about limiting the federal government's power. Originally, the Bill of Rights only applied to the federal government and to land-owning white men. It excluded African Americans and women and other ethnic groups and races. Originally, there were 12 proposed amendments. The amendments not approved would have limited the state's power. It wasn't until after 1968 when the 14th Amendment was ratified, which extended the Bill of Rights to the states. But it wasn't until the Warren Court of the 1960s began to selectively incorporate procedural safeguards in the Bill of Rights to the states. The Warren Court had a liberal majority, so they expanded civil rights, civil liberties, judicial and federal power. Their rulings ended racial segregation and officially sanctioned prayer in public schools. Unfortunately, many of the Warren Court decisions protecting the rights of criminal suspects have been reversed or altered by the more conservative Supreme Courts of the 70s, 80s, and so on. The primary rights we'll cover are the ones that apply to the criminal justice system. 4th, 5th, 6th, and 8th Amendments. Let's begin with the 4th Amendment. It protects the individual privacy against certain types of government interference. It's the Search and Seizure Amendment. This amendment does not give a general right to privacy, as most people think, but rather the question is whether a governmental intrusion violates the Constitution. The government intrudes in our lives all the time, but not all intrusions violate our rights. The Fourth Amendment covers the expectation of privacy that is considered reasonable by the average person. Even though the Fourth Amendment requires that search and seizures not be unreasonable, it wasn't until the 1960s when the Warren Court began to provide a more precise definition of what's considered unreasonable. So, searches are explorations or inspections of homes, premises, vehicles, or persons for the purpose of discovering evidence of crime of persons accused of crimes. Seizures are when the government representative takes something or someone into custody in response to violations of the law. The U.S. versus Mendenhall, a case brought before the Supreme Court in 1980, gave guidelines for illegal seizures. First, threatening presence of several officers, display of a weapon by an officer, some physical touching of the person, and the use of language that indicates that compliance with the officer's request may be compelled. If any of these conditions are met, the situation could be considered an illegal search or seizure. In California versus Hodari, 1991, the court modified the Mendenhall decision, ruling that no seizure occurs unless and until the suspect yields or submits to the assertion of authority. In this case, Hodari ran from the police and the officer pursued, which created a situation where a reasonable person would have believed that he or she was not free to leave. There are two kinds of search and seizures that the Fourth Amendment allows, those made with a warrant and those made without a warrant. The officers requesting the warrant must have probable cause, and they have to sign an affidavit that includes specific descriptions of the place to be searched and the person or things to be seized. Probable cause requires trustworthy and substantial evidence of two conditions. The specific objects to be searched must be connected with criminal activity, and the objects must be expected to be found in the location to be searched. In addition, such warrants generally have time limits. For example, federal warrants must be conducted within 10 days after the warrant is issued, and there are also limits on the time of day a warrant may be conducted. This is true of federal warrants and warrants in half of the states.